One of the most common questions out there when someone dies, you're dealing with an estate, is do I need an attorney? And the answer to the question is yes, you do, because Florida law absolutely requires it. It's Florida Probate Rule 5.030, and it explicitly says a personal representative must be represented by an attorney in probate proceedings. In other words, when you're the PR, you got to rely on an attorney. And I know some people think, hey, I want to save a little bit of money, don't want to pay for that personal representative, but the reality, or the attorney to represent the personal representative, I think I could do this myself. I think that is simple, but the reality is this. Things can get complicated really quickly. One of the things that many PRs don't understand, and frankly, lawyers don't do a good enough job of explaining it to them, is you absolutely can be held personally liable for making mistakes as a personal representative. And this little beneficiary class over here that you are dutifully trying to protect from themselves, and you're doing your job as a PR, and you're trying to respect the wishes of dad, granddad, or whatever that was trying to look out for these knuckleheads over here, they can, and increasingly they will sue you when they don't like what you are doing, and you will be held personally liable. So whatever you took from dad's estate because you were legally entitled to, that could be put at risk when one of these knuckleheads over here sues you and starts coming after you. This is really tricky stuff, gets complicated, gets expensive really quickly. Now, there's another crazy side about this, and that is this. While the law is explicitly clear that a PR must be represented by an attorney in an estate, no such rules exist for a trustee. And so you have circumstances where even a very expensive trust has all kinds of complicated procedures, all kinds of complicated things that may be just completely wrong. They are still being administered, oftentimes outside the supervision of the court, and the trustee is being subjected to lots and lots of liability. Other crazy thing about revocable trust versus personal representative wills and estates. In a revocable trust, there is none of the protections that exist for personal representative. As an example, you may not be a personal representative if your little butt is locked behind bars. Have you been convicted of a felony? Ain't so with revocable trust. Revocable trust, you can be a serial killer. You can be sitting behind bars. Believe it or not, there are prisoners sitting behind bars with lifetime sentences that are trustees of trusts, and they are responsible for administering those trusts. So, these are very interesting topics that are very specific. You got to think about it when you're doing estate planning. You got to think about it certainly when you are trying to administer a estate or administering a revocable trust. I will tell you this. You can't go it alone when you're a personal representative. And as a trustee, you absolutely should not go it alone. There's all kinds of people out there that are doing it. You're going to get burned. If you need more information about this, like and subscribe. Ask for our topic on the subject.